There are different types of licenses that you can get when you've been arrested or convicted of a DUI in Marin County or any other county in the San Francisco Bay Area and within California. Starting from the beginning, when you do get arrested for a DUI, the officers will typically give you a pink piece of paper, which is a temporary license that says you have 10 days to request an administrative per se hearing with the DMV. And if you don't request that within 30 days, your license goes into suspension. You can get a restricted license if your license does go into suspension because you didn't request the hearing, or if your attorney or you do not win the hearing. You typically have a choice on a first offense DUI. On a second offense, you would not. But on a first offense, you can get either a work restricted license, which requires you to go 1 month with no driving, and then typically, depending on the alcohol level, 6 months or a year of work restricted driving, which means to and from work and work related driving. And that's all that DMV allows. I'm not going to get into details on how to, document what you're doing to show it's work related. I'm happy to do a free consultation with anybody to go over that. And that's something that your attorney should explain to you. The other type of license you can get, which is it's a restriction that allows you to drive anywhere, everywhere, anytime, is an ignition interlock license, also called an IID license. And in order to get that, it has some of the same requirements that you would have needed to get that work restricted license. The work restricted license requires you to be enrolled in a DUI school, have SR22 high risk insurance, and pay a reissue fee. The IID or ignition interlock license requires one other step, and that's to have the interlock installed in your car, and then you bring in the paperwork for that, original paperwork, to DMV, and they will have the proof of enrollment in the DUI school and the proof of SR22 insurance, which those companies will have already electronically sent to DMV. And you can get that right away as soon as that, suspension would start. So as long as you have all those things, when your license would go into suspension 30 days after arrest, if you did not request the hearing, or down the road if you did not win the hearing, or if there were a conviction with DMV and DMV suspended your license, the nice thing about the ignition interlock device is you can get it without having to wait 30 days of no driving like you have to with the work restricted license. And you can drive that car you have that has the interlock in it, the IID, anywhere you want. You can take the kids to school. You can go to the mountains. You can go to the beach. You can go to the gym. You can go out to eat. You can do whatever you want. You just can't have alcohol in your system when you're driving, because then the car will lock you out and you get in some trouble for that. But it does allow you to live your life the way you're accustomed to before all this happens. It's just you have this machine that you have to blow into for a certain amount of time. And typically, if there's a conviction for a DUI in court, it's 6 months. If it's a real high alcohol level, it might be longer. And if we were to get charges reduced in court to a wet reckless, and we were unable to win the hearing with DMV, it would only be 4 months with the ignition interlock license.